Hi again, everyone. It's Melissa Steinman. I'm a partner at Venable. I'm here with Christina Vessels, and we are ready to start. So let's move to the next slide. Like I said, I'm a partner in the advertising group here at Venable. And I practice a mixture with a mixture of brands and nonprofits. So we see a whole bunch of charitable sales promotions, commercial co-ventures, sweepstakes, and all sorts of promotions of the types we're going to discuss today come up. So Christina Vessels, who's in the nonprofits and trade associations group, is going to join me. She's an associate in that group, and we're going to talk about some of the issues that come up, the types of promotions we see. As you can see, we've got an agenda here. We'll talk about charitable sales promotions and commercial co-ventures, customer donations programs, online charitable promotions, and some of the newer industry developments. Then we'll move into prize promotions, charitable sweepstakes, contests, and that sort of program, as well as some of the developments with the endorsements and testimonials rules and the use of influencers, mobile giving, and privacy. So hopefully we'll be able to provide both legal insights and some tips along the way. So now I'll hand things over to Christina Vessels to start us off.
Right. Thank you, Melissa, and thank you, everybody, for joining us today. To sort of set the stage, I think we want to talk about, let's see here. Sorry about that. To set the stage. Sorry. Is this the title slide, or are you guys seeing a map of the United States here? Melissa?
I'm seeing the title slide.
Okay, thank you. We're going to talk about industry standards and state and federal laws that apply to cause-related marketing. And so, spoiler alert, it's not just state charity regulators that are in this space. So even though state charity regulators, to be sure, are the ones with primary jurisdiction over charitable fundraising and cause-related marketing efforts. They're not alone, but they are the primary ones. There are about 40 US states that regulate how contributions are solicited for charitable organizations. And keep in mind that for state law purposes, a quote, charitable organization isn't necessarily limited to what the federal tax rules consider to be a charity or 501c3 charitable organization. The state's solicitation rules also extend to situations where contributions are solicited for 501c4 social welfare groups and other types of nonprofit organizations. These charitable organizations need to be either registered to solicit or exempt from registration in these 40 states before they can solicit on their own behalf, or importantly, before they can have third parties like yourselves fundraise for them. And it's these charitable solicitation laws that really directly govern commercial co-venture arrangements, online giving, and related activities that we're going to talk about in more detail. But with this said, individual state charity regulators are by no means the only people or parties interested in how companies and brands conduct their charitable giving and corporate philanthropy efforts. The Federal Trade Commission, for example, has jurisdiction, as you all know, over unfair or deceptive acts or practices in or affecting commerce. So the agency really hasn't been afraid to wield this oversight power. For example, in early 2021, the FTC, together with about 39 state agencies, shut down a massive telefunding operation that the FTC found resulted in about 1.3 billion deceptive charitable fundraising calls. So truly, the FTC is active in this space, and they do have jurisdiction over it. But in addition, there are also there are also independent agencies rather that are taking notice of corporate fundraising efforts. The National Advertising Division of the Better Business Bureau, for example, often through its routine monitoring program, will work to ensure that customers receive what they view as truthful advertising. And this can obviously affect all sorts of advertising campaigns, including those with a charitable bent to them. In all cases, though, whether we're talking about state charity regulators or coalitions of state charity regulators with or without the involvement of federal agencies, their motivations and really their objectives are the same. The question becomes, how do regulators protect the public from representations that either unfairly, unclearly, or worse yet, unscrupulously tug at the public's knack for charitable giving to advance corporate objectives. And so, to that end, you really can consider these to be some driving principles, regardless of the particular law that you're examining for a campaign. So yes, there are state, federal, and industry guidelines to consider when drafting your disclosures or other marketing assets for charitable giving. But I guess it's worth just kind of a quick reminder for everybody that common sense can go a long way too. You want to sometimes think about, would a donor have to think twice about the way you are representing the campaign? Do they have to think really hard about it or do math that exceeds what you can kind of quickly do sort of off the cuff, if you will? So can you, through the marketing assets themselves, as well as the disclosures that you put within your marketing materials, can you make it clear to the public, or clear to them, more easily accessible, more easily digestible, to just kind of simplify the process for the public's understanding of how your campaign will work? Likewise, it's helpful to have your contract with the charity, to the extent that you will have one, really clearly lay out the terms. This is really, probably the best way you can kind of protect yourself is right off the bat, ensuring that you and the charitable organization are on the same page about who's doing what will be said, how will funds be calculated, and the like. So with that overview of the regulatory field and general best practices for informing donors and your nonprofit collaborators about what you intend to do, let's actually look at, what do these campaigns look like? What do you need to know to make sure you're launching a campaign in accordance with applicable law? While Melissa and I are the ones presenting today, what we have to say really truly is a derivative of what you, your companies, your marketing, and your ESG teams come up with. The ways that brands choose to execute on their charitable giving efforts really are constantly evolving in exciting ways. And so you have to kind of think about, well, underlying each of these campaigns, can we boil down the proposal into a familiar framework? How do we sort of fit a campaign into an existing framework for commercial co-ventures, for example, or customer donation programs or sweepstakes, to make sure that you're compliant with law? To start, when we talk about cause-related marketing or cause marketing, this is really a catch-all phrase that describes the relationship, or rather a relationship between a nonprofit and a for-profit company where both organizations stand to benefit, but each really has distinct roles in the effort. Typically, the company is the primary driver behind the collaboration. The company, your company, is the one that derives the benefit, a halo effect, and other sort of positive marketing associations of having your brand seen as aligned with the nonprofit's mission that you support. The nonprofit, by contrast, usually has a passive role in licensing their name and marks. And one of the sort of primary reasons why you'll see that the charity's role is more passive, even though they really stand to benefit from, perhaps the increased sales that you're promoting during your promotion. Part of this sort of passive role is because of how the IRS defines, quote, advertising. It's very different and specific than how you might see it in other contexts. But in really broad strokes, if a charity promotes or endorses your company's products or services, rather than simply thanking you for their support, this can cause the income that the charity receives to be subject to unrelated business income tax, or UBIT. Obviously, that would diminish the value of your corporate support. And so, for this reason, and because incurring too much UBIT can be a problem for charities, you often see that charitable partners are not going to enthusiastically promote the product itself that's the center of your cause marketing campaign. But cause marketing, like we said, really, it's on a spectrum. The very heavily regulated topics like charitable sales promotions, charitable sweepstakes, and related campaigns, we'll talk about those. Those are sort of on the one end. On the other, you have general statements of corporate support, like what you see in the picture here, right? There's no inducement for the public to buy or do anything. Your company simply wants to let its consumer base know that you do good, that you support it. In this situation, you're usually just seeking consent from the charity to use their name and marks. Obviously, you don't see it here. It's kind of cut off from the tag that was over, my hanger from the dry cleaners, but it's got a picture of the National Breast Cancer Foundation's logo on there. But nothing about this sort of dry cleaner marketing really suggests that the purchase itself will lead to a donation to the charitable organization. And so that's kind of, again, your simplest, easiest way to dip your toe into the cause-related marketing field. While this is definitely popular, it's not, I would say not among the most common. But to that end, I think charitable sales promotions conducted by commercial co-venturers, or CCVs for short, probably are the type of the campaign that we help brands with the most. And I think, this is one that probably most of you on this webinar are quite familiar with at this point. But a CCV campaign usually involves an advertisement or other public representation that the purchase or use of a good or service will benefit, a charity or social welfare group or another nonprofit organization covered by states' charitable solicitation laws. So, for example, every time you buy a particular item or every time you use our service, like the credit card, for example, we, the company, will donate a set amount to the named charitable organization. That is a charitable sales promotion. But sort of a quick aside on what is colloquially referred to as a free action campaign. This is sort of a subset of charitable sales promotions, if you will. They have sort of the same structure, but exist slightly outside of the realm. Sometimes you see a campaign that involves a totally free consumer or public action. For example, you might be asked to post a picture to social media with a particular hashtag, and then the brand will advertise that it'll donate for each of those free actions. Since that type of free action campaign does not involve the purchase or use of your business's product or service, typically this is viewed as outside of the charitable sales promotion rules. Though I'll note, a few states have slightly broader laws that could conceivably, cover this type of promotion. So really you do need to kind of analyze the campaign on a case-by-case basis. Plus, in those free action campaigns, you might have other situations like user-generated content and other laws that may apply. So just kind of food for thought as we go through the CCV rules. But what does it take to conduct a compliant nationwide charitable sales promotion? As an initial matter, as we said up front, you want to make sure that the charity is registered to solicit nationally, because if they're not registered wherever you're going to conduct the campaign in a 50-state promotion, that could actually cause some hiccups for your registrations and require you to, maybe reconsider the scope or structure of your promotion. But assuming the charity is registered, then your first step is to prepare a written agreement. It gives you the charity's consent to use their name and marks, includes, certain state law required items. You'll need to consider where your company needs to file registrations. Sometimes you need to file bonds in a few states. But all of this really has to happen before the campaign goes live. So while I know in practice, it does not always, these types of campaigns don't always present themselves with a significant amount of lead time, to the extent that you can work with your marketing teams to say, when you're considering this type of framework, build in some time for compliance on the front end. That is always helpful. In terms of post-promotion filing obligations, typically you need to submit reports to both the state and to the charity, detailing the results of the campaign. And that's just kind of good practice, even if it weren't required by law. You want to make sure that everybody is in alignment over what has happened, how much is going to be paid, and those kinds of key terms. But in between, while the promotion is ongoing, this is really where you need to make sure that your CCV efforts are buttoned up. Keeping with the transparency theme that we were talking about just a few moments ago at the start of the presentation, the marketing materials for your charitable sales promotion need to make clear all material terms. State laws are actually pretty sparse when it comes to what disclosures they require. Typically, state law simply requires, outlining the per unit amount that your company will donate to the benefiting charity, whether that's expressed as a dollar amount or as a percentage of the purchase price. But there really isn't too much more, at least from state law, that is required for your CCP disclosures. With that said, industry standards, litigation on the matter, and other sort of technically non-binding guidance documents have generally led to a comprehensive set of disclosures seen as, must-haves for CCV campaigns. You need to make sure that the start and end dates of the campaign are made clear to consumers. You need to make sure if there are any minimum promised amounts to the charity or any maximum limits on how much you might donate based on consumer purchases. Those terms all need to be made clear. And when, so far what we've been covering is really the regulatory landscape for US-based charitable sales promotions. But if your company is going to be actively marketing a campaign abroad, particularly if there's going to be an in-person or an in-store component in a foreign country, you really should be confirming the requirements of the relevant host country. Yes, there are plenty of similarities in how other countries regulate commercial co-venture activity, even if they might call it a different name. But it is by no means identical across borders. Within the UK alone, for example, Scotland, England, Wales, Northern Ireland, they all have fairly similar regulatory frameworks, but there are variations between the constituent countries of the United Kingdom. Scotland, for example, has a pretty tight turnaround for when donations need to be transferred. It's 28 days after the funds are raised. Other countries, for example, might specify specific disclosure requirements, or might limit how you reference the charitable beneficiary. For example, some countries might say you can't call the charity a charity unless it is a charity under that host country's rules or registered with the host country's regulatory authorities. So in short, at least for active marketing of particularly in-store or other sort of in-person fundraising events in other countries, it's not enough to simply comply with US law. You really should weigh pros and cons of seeking out counsel in those local host countries. But let's shift it back, I guess, to domestic campaigns, and we'll talk about a second or third, depending on how you look at it, framework. So in addition to charitable sales promotions and free action campaigns, let's consider customer donation programs. For now, at least, these types of campaigns where customers are given the chance to add money to their purchases, these have historically been among the easiest types of cause marketing campaigns to launch. The customer's donation is entirely elective. Sometimes there are parameters on how the donation is made, right? You might say, okay, this is a roundup customer donation program, or this is, you're given the option to add an amount of, the customer's choosing to your bill. Usually this type of arrangement follows the rules for charitable trustees, and the company and benefiting charity need to document in an agreement how funds will be raised, how they'll be transferred to the charity, whether donation receipts are going to be issued by the company or the charity. If it's the latter, how are you going to share customer/donor information with the charity? Sort of these types of related administrative considerations. And I do think, the biggest issue with this type of campaign historically has just been ensuring that 100% of the amounts raised for charity are actually transmitted to the named charity in a timely manner. This is important because, the company, you'll be acting as a limited agent, you'll be acting as a volunteer rather than as a person who is paid to help with the charity's fundraising efforts. This distinction really is important because if a company is viewed as being compensated or receiving other consideration in exchange for soliciting funds for charitable organization, this can actually throw you into the regulated category for professional fundraisers. And that status typically carries significant regulatory compliance obligations. And so you really want to make sure that you're not accidentally or inadvertently tripping those wires and subjecting your company to professional fundraiser rules. And again, the main way to protect against this is to ensure, that 100% of the amounts raised for the charity reach the charity. But starting January 1st of next year, of 2023, these customer donation programs that are conducted online and many other online fundraising efforts are going to face a sizable regulatory shift. California signed into law Assembly Bill 488 last fall. And so what that bill did is it is now going to regulate charitable fundraising platforms, platform charities, and other people or entities who use the internet to facilitate or permit or otherwise solicit contributions for these charitable organizations via online efforts, at least in California. As of a few weeks ago, proposed regulations were actually put forward by the state. So the newly regulated public really now has something to which you can, react and respond. But importantly, whereas before this law passed, various types of online fundraising efforts like customer roundup campaigns or charitable sweepstakes or choose a charity fundraising options, things like that, those didn't always have a clear regulatory framework to guide those types of promotions in terms of compliance. So often companies and their nonprofit partners were left to look, at FTC guidance or, the multi-state agency involving PayPal's charitable giving fund and other sort of not directly applicable sources. Now, at least, there's one state that'll have a codified framework that online charitable fundraising platforms will need to follow. And as enacted, the law will require these platforms and platform charities to register with the California AG to satisfy certain reporting obligations and publish disclosures in connection with their efforts, among other requirements. So this part is really important. I think it's worth just kind of calling it out here. If your company is going to, beginning next year, conduct online efforts to facilitate, permit, or encourage donations to occur based on consumers' choices or actions on your website or through your platform or mobile app, you really need to start paying attention to whether, or more likely how, the California law will affect your compliance obligations come the new year. The law is going to affect companies who principally fall into one of 5 categories. First, those who list one or more charities as eligible to receive donations made by donors on the platform. Second, those who permit their platform to fundraise through peer-to-peer charitable fundraising efforts. Third, those who allow people to use the platform to select one or more charities that will be made to receive donations, which donations will be made by the platform or another third party based on the customer or user's purchases or other activity. A fourth category for regulated platforms will be those that list one or more charities as receiving donations based on purchases or other activities, sort of like a commercial co-venture type feel. And finally, those who otherwise give charities a customizable internet-based website, service, or platform to allow the charity to go out and sort of expand on its fundraising efforts. So let's kind of set the stage here and walk through how this might affect one of you. And to be clear, the state right now is considering proposed regulations. So some of these, technical compliance considerations that we're going to talk about really aren't yet codified, and there's still some chance that they will change. But let's consider, a quick hypothetical based on the state's proposed regulations. Say your company sells a product online or through its mobile application, and you give customers the choice to round up their purchases so that the extra change goes to one of the charities that you've contracted with, for example, in advance of the program. Your company will collect the funds and transfer the amounts 100% to the charity on a periodic basis. Under the new law, it to me sounds like this is providing a website or internet service that lists or references by name one or more charitable organizations as eligible to receive donations made by donors who use the platform. That seems like it would qualify the company in that example as potentially a commercial charitable fundraising platform. So according to the proposed regulations, there's going to be a host of compliance obligations to consider, and many, if not most of these, need to be addressed on fairly tight timetables as set forth in the regulations. Based on CCV campaigns that your company may be familiar with, some of the requirements will be familiar, like registering with a state authority, having a contract in place with a charity, including certain disclosure terms and even post-event reporting. That's kind of a general framework that, many of us have grown accustomed to in the CCV context, at least. But AB 488, that new law and its implementing regulations really go further. Yes, the commercial charitable fundraising platform in our hypothetical would need to do all of those states. They would need to do all of those steps. But in addition, they'll be verifying that the charity partners are in good standing with the IRS in California. And really, here's where I think the rubber's going to meet the road for these new platforms. New types of requirements that these fundraising platforms are going to need to consider, at least based on our hypothetical. The commercial charitable fundraising platform would also need to create a separate account for maintaining donated sums made through the platform. You would need to send donors with a tax donation receipt within 5 days of their donation being made on the platform. The funds need to be transferred to the charity within 15 days of being made. And once those donations are transferred, you actually would also need to inform the original donor that the funds have been transferred to the charity unless the person opted out of receiving this notice. So, this really is a pretty big shift in how online roundups and other types of customer giving campaigns are likely to be used. Some states are the same, but certainly there's going to be a lot new to consider here. And beyond, the administrative and technical compliance considerations, platforms are really also going to need to consider what it means for their disclosures to be, quote, conspicuous in order to prevent a likelihood of donor deception, confusion, or misunderstanding. We've talked about, some of these particulars in, prior alerts and presentations, but there's going to be a whole lot more, right? You're going to have to explain situations where the recipient charitable organization may not receive the donations or recommended donations made through your site and the reasons for why this may or may not happen. You'll need to inform the public about the maximum amount of time it'll take to send a donation, together with, sort of an explanation as to why it'll take the amount of time that it will take to transmit that donation. Other kind of key terms like, any platform fees that you charge and things like that, whether the donation is tax deductible, will need to be included. And for purposes of California, these disclosures will all need to be adjacent to the content being explained in at least the same font size. And, as I mentioned before, you'll need to provide certain information to donors unless they opt out of receiving notices. So this would be kind of another place where you might be considering including a checkbox with your donations or, the transaction process on your platform to make sure that that's addressed. So in short, this law and its proposed implementing regulations are really going to require some reflection from companies before the end of the year. Some of you are who are used to conducting charitable sales promotions, even those that are conducted online, may not have to follow this new framework. If you are doing CCV campaigns for 6 or fewer charities in a year. But many of you are going to have entirely new compliance considerations, cryptocurrency donation conversion services or charitable sweepstakes or, other types of campaigns are going to need to consider, how this new law will affect your operations. And so, I do think certain issues are going to be addressed in the state's public hearing on July 13th. But certainly now is the moment to think about what these regulations mean for you and whether or not you want to submit comments on them before the July 12th deadline. So I think this kind of is a good segue into Melissa's kind of more in-depth conversation on charitable sweepstakes and the like. But before I turn it over to her, for those of you watching today's presentation for CLE credit, please note that the CLE code is Compliance 2022. Again, the CLE code is Compliance 2022. And with that, I will turn it over to Melissa. Thank you.
Okay, great. Take the mute off. That's always a good start. Okay, so let's move over to the next slide. In this section, we're kind of going to talk about the everything else in terms of the specialized types of promotions we're seeing today. We, of course, have people coming up with all sorts of newfangled promotions, new spins on old-fashioned promotions that are being run by or in conjunction with charities, whether it's crowdfunding efforts, streaming, charitable promotions on Twitch or other platforms, social promotions, free action promotions being run on Facebook or Instagram, where you can tweet or post, and 5% of your post will be 5% of your purchase, or $5, I think, is probably the better model there of, will be given by X brand for every post you make on Facebook to Y charity. All sorts of different types of creative promotions are being done now. That may be regulated in or may not be regulated in some way that's different from what we think about as a traditional commercial co-venture or charitable promotion. And we get questions like this all the time. So we're going to try to cover some of these. We may not cover all of them, but it's important to be thinking about, when you're giving some sort of money to a charity, is that going to be covered by the commercial co-venture laws? So we'll start out, next slide, by talking about sweepstakes and contests and giveaways, and how they may be covered. So federal and state laws, for anybody who's worked in this area, of course, prohibit lotteries. Lotteries have the magic 3 elements, which are the awarding of prize given away by chance, where there may be some sort of consideration, whether it's a purchase or a payment or some sort of non-monetary substantial commitment of time or effort or something of value either to the entrant or to the sponsor of the promotion. So that analysis can be complicated sometimes, particularly on the consideration issue, but is very important because if you violate the lottery laws, which is a type of gambling, then you may be participating in some sort of criminal activity. So we all care about that, of course, because nobody wants to be committing some sort of criminal violation. So it's interesting because one thing people don't always think about is that the types of activities that are legal activities, like legal charitable raffles or legal promotional sweepstakes, are actually types of what are narrow or relatively narrow and specific exceptions to this broad category of lottery law or lottery prohibition. And so it's a situation where typically, unless it falls into one of these sort of carve-outs or exceptions, then it may and typically won't be legal. So when somebody like me, who's a sweepstakes lawyer, listens to your concept, I'm sort of saying, well, could it be this or could it be that, as opposed to, well, it's not a lottery. And that's one of the things that's actually trickiest in the areas that we're talking about here, where it's potentially a charitable giveaway, because while charities have this narrow exception specifically for them to the lottery laws, that is the charitable raffle. Typically, that is a very narrow exception, and where you have to, you may be able to actually require consideration in the form of a payment for a raffle ticket or the like. But it's very specifically carved out under state laws. It varies from state to state. And it's the requirements can include not only the kinds of registration that we all think of, but also things like California limits the ability, you can't sell tickets online. And you can't allow third parties to participate in the offering of the raffle. That's not a unique requirement to California law. So the ability to allow for-profit brands to participate in a legal charitable raffle, and the ability to offer it nationally online, because there's frequently limitations on the ability to advertise online, sell tickets online, which is also, by the way, maybe limited by the federal postal laws, can be very limited. Also, the ability of to do it nationally can be limited by, say, requirements that an entity be located physically in a jurisdiction where the raffle is being offered. These kinds of requirements can make it very difficult to run a national online raffle for charitable purposes. So what's now sprung up is this concept of the promotional sweepstakes. And it's become very popular, and we're seeing it in on online sites like Charity Buzz or Prizeo or the like. Florida has a specific law that allows charitable nonprofit sweepstakes. It's a little less clear whether it's permitted under every state's law. So certainly what you want to do is comply with the sweepstakes laws when it comes to things like disclosures of material terms like start and end dates, or what the prize value is, or that sort of thing, and how those disclosures must be made, which we'll talk about in a second, as well as things like consideration and the like. And then we'll take it from there. But let's talk for a minute about what's been going on in the world of charitable sweepstakes laws, including some of the Attorney General cases and litigation on the next slide. Okay. With regard to charitable sweepstakes specifically, these have become very popular. I mentioned the Florida law that's listed on this slide. Another issue that's come up here is that when you do have a for-profit entity, like some of these charitable sweepstakes sites that are working with not-for-profits in offering these, you want to make sure that that for-profit entity is registered as a promotional fundraiser under the state laws that require that sort of thing. Christina, I think, has mentioned that, but that's a specific type of law that requires that if a for-profit is working with a charitable entity in participating in fundraising, then that may be required. There have been several cases brought by the California Attorney General against these promotional sweepstakes or these charitable sweepstakes websites. They were spurred initially by actually the fact that these sites let their promotional fundraiser registrations lapse for various reasons. And so these investigations were opened. Ultimately, there was a settlement and there were cease and desist letters filed against two companies, and one settled it or a third company settled OMAs. The OMA settlement involved a number of requirements, but in particular, the company agreed not to let its promotional fundraiser registrations lapse again, and to the extent it works with a company called CAFA, which is a charitable entity that then distributes. If you're familiar with OMA's structure, essentially what it does is it solicits donations as a form of entry into multiple sweepstakes. There's also a free alternative method of entry offered if you don't wish to donate in order to enter. The donations then go to CAFA, which is this charitable entity, which then distributes to the individual charities the donations that are participating in or receiving the benefits of individual sweepstakes. So that's how that specific setup works. And to the extent under the settlement that OMAs changes the relationship, then they have to notify the Attorney General's office. Additionally, the Attorney General's office had challenged the disclosures of the free alternative method of entry as not being sufficiently clear and conspicuous. And so that's something that is important. Whether there's a free alternative method of entry and whether it's sufficiently clear and conspicuously disclosed is an issue that comes up a fair amount in both, charitable and non-charitable sweepstakes promotions. So it's incredibly important in order to make sure that your legal sweepstakes doesn't become an illegal lottery. To make sure that if there is a purchase or payment requirement to enter, that you clearly and conspicuously disclose or offer a free alternative method of entry and then disclose it in a way that everybody will see it. In OMA's case, there's a clear button that's equally large to the donate to enter method at this point. If I go to the website and seek to enter without donating, I will see that right away. In addition, what OMAs had actually offered or argued here was that they did not fall under the provision of the penal code under California law that prohibits lotteries, Section 320, because there is an exemption from the raffle provision for raffles that offer a free alternative method of entry, provided that there's a general and indiscriminate distribution of tickets, which are offered on the same terms and conditions, and nobody is required to pay for a chance to win. And ultimately that was accepted by the Attorney General, and the case was settled. So next slide. Let me just go on and reset. Therefore, what can we take away from this in terms of compliant charitable sweepstakes if you want to go this sweepstakes route, because a raffle won't work when you're working with a charity and a for-profit brand. You should make sure, of course, that you should offer a no donation method required. Make sure that it is clearly and conspicuously disclosed close to the method, the donation method required method of entry. Any other disclosures, things like start and end dates, other material terms are also made. You have a good set of rules. You should be obtaining, of course, the charity's consent to use their names and marks, give them approval rights over other uses. The donation should be promptly transferred or even have a direct donation route. Of course, the charity should be in good standing with the applicable state and federal authorities. When you think about how should those disclosures look, of course, the OMA settlement is a good example, but also the PayPal Giving Fund settlement gives us some good guidelines, as well as the FTC's .com disclosures, which is currently being updated to sort of keep up with current platforms and current methods of disclosure on those platforms. So we'll see some updates within the next year or so, but it does have some good guidelines on how to make unavoidable and prominent disclosures when fees are charged on disclosures, or fees are charged on donations, how much is charged, how an intermediary charity may be used. We should be disclosing things like the name and contact information for the charity and their tax-exempt mission. Is the donation tax deductible, which is usually not the case with sweepstakes? And what information will be shared from the donors. One thing to note, actually, OMAs has been sued in a class action now called Nuttall v. OMAs, which is alleging, again, failure to disclose the alternative method of entry and the odds, but also misrepresentation about the portion of the donations that OMAs was keeping, in terms of what was donated as part of every sweepstakes, and then what was going to CAFA. OMAs was keeping a significant percentage of the donations. The amount depended on whether they were buying the prizes or whether they were being donated by third parties. And so the plaintiffs in Nuttall announced, or rather claimed, that they were being misled about that because it was not being clearly and conspicuously disclosed. That is being ongoing. Actually, the claims about the failure to disclose the AMO were dismissed, as the lottery claims were dismissed, but the deceptive and misleading claims are ongoing. Next slide. Next is non-NFTs and cryptocurrency. Some interesting issues have come up now just with regard to giving away NFTs as prizes in sweepstakes. This is sort of the hot new thing. I talked in more detail about this in a webinar last week. We did a 3-day webinar about NFTs. So if you're really interested in this topic, we can talk in more detail. But really, there's some interesting issues that have come up. About disclosures again. The requirement to purchase an NFT can be consideration. You need to disclose that you need to offer an AMO and disclose that purchase isn't required. There's also an interesting issue because an NFT really doesn't have value when it's first offered. The value is later set in terms of sales on a secondary market and the like. So unless you are actually buying an NFT off of a secondary market, if you're creating it essentially from scratch and burning it, then it doesn't necessarily have a value yet. The other thing is you need to be very clear when you give away an NFT what rights you're offering, because typically it's not like you're offering all the rights to the NFT. It's a very limited bundle of intellectual property rights attached to a smart contract, and about what people have to have or do in order to be able to accept the prize, such as have a crypto wallet, and then or open one in order to be able to accept. There is a class action in this area called Susky versus Coinbase that alleges that there was a failure to disclose the AMOE. So as you can see, the class action attorneys are already active in that area too. The next slide does involve an NFT platform offered by Melania Trump. And here you can see what can happen when you offer an NFT. The circled text, Trump's statement said a portion of the proceeds from the NFT auction at issue will assist children aging out of the foster care system, but her office did not respond to questions about how big a portion it would be. So you can see, again, you have to disclose what's being given, who it's being given to, what rights are involved with the NFT, that sort of thing. All of this is very important, even when you're giving away interesting new technology. With the endorsements rule, this is a reminder that with charities and with sweepstakes, when you offer the opportunity to enter into a sweepstakes, you need to tell entrants that if you are asking them to post online in order to enter, or something like that, or if you just ask them to post online about something that they received, then you need to ask them to disclose that. So whether it's hashtag sweepstakes entry or hashtag I won or hashtag free gift, you do need to ask people to disclose. The same goes for employees who are promoting a sweepstakes. Employees are expected to promote what is a material connection that the FTC believes must be disclosed online, so that it's clear that employees, sweepstakes entrants, or the like are not just posting because they love the charity so much, which I'm sure they do, or the brand so much, but because they have received something of value from the charity or brand, and that is influencing why they are posting. Next slide. We are getting towards the end because I know we're at 3 o'clock. Just a reminder that whenever you make a claim, whether it's about your charitable promotion or the charity itself, you need to substantiate those claims. This is something we're mentioning here because in particular, the National Advertising Division, which is part of the BBB, it's a self-regulatory group, has been focusing on this lately, and has brought a couple of cases. If you are talking about your campaign or your charity, or for that matter, your brand, you need to be able to substantiate your claim. If it's about the donations, have invoices, have donation acknowledgement letters, executed contracts. This is all stuff you'll need for charitable solicitation law purposes as well. So hopefully you have it on hand. So the NAD, I mentioned these cases. They have opened up some cases lately, which were happily all substantiated against DoorDash and Niantic about claims regarding how much those companies had donated to respectively the Black Lives Matter campaign and various related nonprofit organizations to support the rights of Black transgender people, and organization nonprofits supporting child learning and development. The NAD has the right to either hear challenges from competitors or they open up their own investigations. In both of these cases, they looked at the charitable campaigns, they asked for substantiation, and the two companies proved them. But you should just make sure that if you're going to make a claim about a giving campaign, that you have the ability to substantiate it should you ever receive a similar request to substantiate from NAD, from the FTC, from the state AGs. Keep those records. All right. Final slide on the substance mobile giving campaigns. These are really popular. Often you get third parties like MGive or the like who are running them. This is a reminder that if you are collecting the telephone numbers to text or call people through these campaigns, you need to get prior express written consent to text consumers directly under the Telephone Consumer Protection Act. Also, helpfully, the CTIA, which is the Mobile Wireless Association, will offer short codes at a discount if you follow their rules. You can find all of those rules online, but you do have to comply with the Mobile Marketing Association's guidelines, provide consumers with separate opt-ins for each one of your fundraising activities. And you'll also have to comply with the carrier rules for these types of activities. But you do get the discount on the short codes, which is a great thing. And finally, remember your privacy rules. The rules do not apply to nonprofits, but they, of course, apply to the brands working with them. And plus, there's the expectation that nonprofits will be complying with the same rules regardless. Remember that the CCPA now has, of course, heightened the rules in terms of things like the right to know what's being done with personal information, the right to opt out from collection, the right to ask that personal information to be deleted and the like. And so you need to understand those rules, offer the right to opt out and to have information deleted, and be aware there. With the CPRA now, what used to be a 30-day right to cure that California was offering as of July 1, there will no longer be that right to cure. So enforcement has been stepping up, and the ability to just fix it once you get a letter is going to be removed. So you need to be, the brands in particular need to be careful. Hopefully you're well on the way towards 100% compliance if you're not already there. And I think that I'm turning it back to Christina for the wrap up.
Yeah, thank you, Melissa, and thank you for everybody for tuning in today. We've covered a lot of topics ranging from the state charitable solicitation laws to FTC rules, whether it's on mobile giving or endorsements and testimonials, state lottery laws affecting sweepstakes. So there's a lot here, and we hope that these may offer at least some initial questions that you and your marketing teams can think about when you are coming up with your cause-related marketing presentation proposals and promotions. As we mentioned, the California law on online charitable platforms, the state is accepting comments on the proposed regulations by July 12th, and there will be hearing on the 13th. We hope that we'll be following that up with more news alerts for you on the subject. And if there are any nonprofit organizations that have been watching today, we're going to have a part 2 on cause-related marketing and the online platform rules at the end of July, on July 20th. So we hope to see you then for more on cause-related marketing. And with that, thank you all. I know we're a few minutes over time, but I really appreciate you all tuning in and hope to hear from you soon. Bye.
Bye-bye.